The Fellowship of the Great Physician welcomes you to House Call. Our hosts today are doctors of chiropractic, Dr. Gerald Lala and Dr. Richard Jensen, who is also a board-certified acupuncturist, practice independently in North Oaks, Minnesota. Let's join our hosts for today's program that will assist you in your quest for optimum health and well-being.
Welcome to House Call. I'm Dr. Gerald Lala. It's good to have you with us. And as the screen says, we're going to be discussing medical malpractice today. And we had this idea of doing a program or a couple of programs like this because we've never seen a medical doctor, chiropractor, dentist, ever do anything on television that discussed malpractice. And so we've invited Thomas Bennerat, specialist in malpractice and personal injuries, to be a guest today and to discuss medical malpractice. Welcome, Tom.
Thanks.
Great to have you with us.
Nice to be here.
Let's start out with just a very simple question. What is medical malpractice?
Well, in its simplest form, it's injury or death that occurs as a result of an improper or negligent medical treatment. Basically that probably lends itself to the question of what is negligent medical treatment. Negligent medical treatment is when one of two things happen. Either when a healthcare provider does something that a reasonable provider wouldn't in the same circumstances, or when they fail to do something that a reasonable provider would do in the same circumstances.
So it becomes then a question of, let's say that you're a medical doctor and I'm a medical doctor, which of course I'm not. And it's then a decision, do you consider it reasonable with what I did, or do I consider it reasonable?
Yeah, well, in essence it's that, but it even goes a step further, and would another provider have done a same or similar thing in the same circumstances?
So reasonable is a significant word then.
It is, and it's obviously it's not black and white.
Okay, then could you give us some examples of healthcare provider as you've termed them? What would they involve?
Okay. Well, medical malpractice can occur in a whole bunch of different forms. It can be a medical doctor, it could be a nurse, it could be a hospital which has a number of different employees, be it respiratory therapists or whomever. It could be a clinic facility which may commit malpractice either through the doctors or potentially even through lower level employees, lower than the physicians or nurses. A chiropractor, could be a physical therapist, it could be a dentist.
How about a massage therapist?
Could be a massage therapist. Mm-hmm. It's anybody that essentially is licensed or requires to be licensed in the state of Minnesota in order to carry on their profession, oftentimes is subject to committing medical malpractice. Okay. Another one that comes to mind actually now is a pharmacist through a medication administration error. But it can occur basically in a medical facility, and it could even in theory occur in your home if you had a medical provider that came to the home to treat an individual.
So how about acupuncturist? Would that include that as well?
It would include that as well.
Are there other terms for medical malpractice?
There are. In fact, the one that I often kind of use interchangeably with medical malpractice is medical negligence. I've also heard it termed medical misadventure, a medical mistake, a medical mishap. The other one that is more of a cutesy term, as I'll define it, is an iatrogenic illness or mishap.
What does that mean?
Well, iatros means physician, and genic means, to be induced by, so together it's disease induced by a physician. I think, frankly, a lot of times that's probably a term I've seen more in a medical note than anywhere else.
And misadventure is far different than crossing sexual boundaries.
Correct.
And sexual boundaries, is that malpractice?
Well, no. Well, typically the way I would look at a sexual boundaries issue would be more of an intentional type tort. If it's alleged, quite often at least, of course it could always be misconstrued as something that was sexual in nature that wasn't intended to be. But when you cross that boundary, typically if found guilty of sexual assault, I guess as you term it with a physician, it typically would then be deemed intentional.
Okay, and let's say that you've been on both sides of the bench, that you've defended doctors in malpractice cases from the corporate level.
Correct.
And now you're a plaintiff's representative.
Correct. What I first did is I worked for an insurance company and basically worked with HMOs, worked with doctors, clinics, a number of different practitioners, helping them with claims, and then later, after law school, went to represent parties injured as a result of medical malpractice or medical negligence.
Now, what happens if I, as a chiropractic physician or a medical doctor, stops at the scene of an accident, a collision, and I dispense some medical care, and then the victim or the injured person or their family decides to sue me for malpractice? Is that a possibility? Or?
Well, it may depend on the factual circumstances, but typically in that scenario, you're going to be considered a good Samaritan. Public policy suggests that we want somebody at the scene of an accident not to feel like they can't help because of fear that something bad may come about from it. So in that scenario, you're going to be protected. I believe, if I'm not mistaken, there have even been scenarios in which when you were at the scene, somebody maybe didn't provide care because they were concerned about the consequences that could come about from it, and they were actually reprimanded for not helping too. So it's maybe 6 of one, half a dozen of another. But typically, you're protected under the Good Samaritan laws so that you can provide help without worrying about whether something bad could happen and you could be sued.
Would then police and paramedics be under that same law then, in, say, in Minnesota, for example?
They're under a similar law, correct?
Similar law. How prevalent is medical malpractice?
Well, medical malpractice kills approximately 98 to 100,000 people in just hospitals every year, according to different figures I've seen. I don't know how many people a 727 carries, but I've heard it estimated that the prevalence of medical malpractice in hospitals alone in this country would be similar to a 727 crashing every day. When you think about it in those terms, it's obviously a huge issue. And the costs associated with medical malpractice, disability, and those sorts of things are about $29 billion a year, which when you look at it, I guess, in those two ways, it's obviously a huge, huge issue.
I saw a report by the Institute of Medicine that was a historic report that was released in the year 2000, said to err as human, building a safer healthcare system. Do you have any reflection on that report?
Well, yeah, I mean, that's kind of the report that talked about and kind of brought a lot of those numbers to light. It's, I think it emphasizes a statement that I've heard used before, that, I mean, the medical malpractice that we see as practitioners is just the tip of the iceberg, and that there's much, much more of it out there that we never see as practitioners.
What are some of the other elements of a medical practice, a medical malpractice situation?
Okay. In order to have a valid malpractice case, you have to have a couple different things. You have to be able to show, like we talked about before, that a healthcare provider acted negligently, meaning, in different terms, they departed from the standard of care. Okay? In addition, you need to be able to show that an injury occurred and that there's harms and losses as a result of that negligent conduct. And then the negligent conduct has to be shown to have played a substantial part, and that's kind of the buzzword legally, in the injury or death that resulted. So it's, somebody acted negligently, somebody got hurt, and then proving a causal connection between those two things and what came about from it. Mm-hmm. The call I get sometimes is, I got the wrong medication and I went home, and something bad could have happened, but they found it. In that scenario, it's kind of a situation where you say, well, was there negligence? Sure there was. They got the wrong prescription, but did it cause any harm? No, because they caught it before it did.
Okay. What are some of the most common malpractice cases or situations?
All right. The most common ones that come to mind are birth injury, delaying diagnosis of breast cancer or other cancers, failure to diagnose or treat heart attacks or other medical emergencies, failure to diagnose serious medical conditions, appendicitis, maybe a bowel issue of some sort. Other ones, and the ones that are becoming more prevalent now, there's more gastric bypasses being done, so there's claims that arise out of that. Unnecessary delay in treatment of a diagnosed medical condition. Oftentimes there's surgical or medical mistakes that occur where it's either a surgical error and or an anesthetic error. Some of the other ones, again, that are becoming more prevalent as our population ages are nursing home cases, whether it be abuse or neglect, whether it be bed sores or pressure sores or malnutrition, or just a lack of care there.
And that's going to be really more and more prevalent. I have a daughter who used to a wound care specialist, and so or she worked for a large international organization that sold wound care products. And of course, she visited hospitals all over the United States and nursing homes and dealt with major health insurance companies that were paying for these different salves and creams and bed sore bandages and things of that nature. And she never really talked about what she thought was medical malpractice, but it was the issue that the number of people, not just burn victims who were being institutionalized, but older people, geriatric patients, and she said, "Dad, this thing is really going to be bad."
Well, and as the baby boomer generation ages, the more people you have in this situation, the more bad things that can happen there, and populations become, there's more people there, and just basically a greater number of individuals to have issues.
Let's say that I was a surgeon. Of course, I'm not, but that we did some gastrointestinal surgery and somehow left a sponge inside of somebody, and that created an infection. They were back into the hospital and found this sponge. Is that malpractice?
Absolutely. In fact, I handled a case similar to that within the last year. That's one of the, probably what I'll call, not slam dunk malpractice case, but on the simpler side of determining what is clearly malpractice.
So I, as a surgeon, then I'm the responsible one for that?
Well,
or is it the surgical nurses, the anesthesiologist? Is it the hospital as well?
It could be either or both, because typically in any surgical procedure there's a sponge count that's done at the end. Oftentimes that's done in typical facilities by multiple people, meaning checks and balances in place. So it could be a surgical or a surgeon error in that situation, but more likely it's going to fall back to the hospital, who has the people in place performing the sponge count checks and those things.
I know my wife years ago was having kidney stone issues repeatedly, and they just simply prescribed analgesics to get through it, and so we decided to do a bunch of blood work ourselves on her and found her calcium was high, and encouraged a general practitioner to make a referral, and they found that she had a tumor on one of her parathyroid glands. And so that was fine, and took her down to the hospital at 4 o'clock in the morning. They were going to do the surgery and do a parathyroidectomy. And so, it's really early in the morning. The surgeons are starting to come in, and staff. And this nurse comes in to the pre-op room and says, "You're a thyroid." And my friend Peter and I were standing next to her where she was laying on a gurney, and we said, "No, it's a parathyroid." And she said, "Right here it says thyroid." Well, we knew the surgeon quite well. He's just a great guy, And he heard us out there, and he came in and said to the nurse, "No, it's a parathyroidectomy," and it was that case. Well, we had another friend who had been involved in a bad motorcycle accident, was hit by a truck and really died 3 times, brought him back to life. It was really a big mess. And so they left several rods in his arms and his legs, and they were going to take these out about a year later. And he went and took a big felt tip pen and marked this arm, that shoulder, this leg, And he was telling me about it on the phone, the night before. And I said, "Oh, his name is David." And I said, "David, you don't have to do that." And I talked to him later that day after the surgery, and he said they were going to do the other arm, the unmarked one, So some people can get really tough about those things. So
you never can be too careful.
Never can be too careful. And it isn't that we're not accusing the doctors. Yes, they're responsible. We're responsible. But I can't believe that any doctor would do the wrong surgery intentionally.
Right,
I mean, there's got to be something wrong here, and down here to do something like that. So how long does a person have to bring a medical malpractice claim? Is there some statute of limitations? Or?
Sure. There's a time frame, and in Minnesota, the general time frame is 4 years from the date of the negligent act, in which you have time you actually have to bring the malpractice case. If we go back to the scenario you brought up before with the sponge and take that, the interesting thing is that Minnesota doesn't have a discovery rule. I think we'll talk a little bit more about that in a moment maybe. But what that means is that in the case with the sponge, maybe it's left in you and you don't realize it right away. You don't feel well, you go back to the doctor, but they can't determine the cause of why you don't feel well. Let's say 4 years and 1 day after you had the surgery where they left the sponge in you, it's determined that the sponge is in fact the cause, in that scenario, because Minnesota doesn't have a discovery rule, it's a strict 4-year provision, you would be prevented from bringing your claim. Or you could bring it, but it likely would be dismissed because the time frame's gone.
And that goes through some court?
Yeah, it would go through, you'd bring your claim in district court, and likely the other side would bring what's called, probably in that case, a motion to dismiss. And in that scenario, what would likely happen is the case would be thrown out.
Well, you have children, I have children. Let's say that malpractice occurred, or we believe it was, on one of our children when they were a minor. Do we have that 4-year statute of limitations there in a minor? Or?
Yeah, good question. And actually, there's the 4-year limitation that I brought up before is a general statute of limitations. It's not a strict. There are exceptions to it, one of which is for minors. Depending on the age of the minor when the negligence occurs, there may be a 4-year limitation for the parents to bring any claim for the minor for things like recovery of medical expenses, but the minor themselves, depending on the age that they were at when the malpractice occurred, could have anywhere from 4 to 11 years to bring their claim.
So then in malpractice claims like, say, no-fault law, is there also a liability and a medical expense aspect then?
No, it's different than auto
Different.
cases.
All right. That'd be interesting to hear about.
All right. As opposed to auto cases, which we talked about in a different segment, in an auto case you have both you have a no-fault portion of your claim where you try to get medical bills paid and other expenses like wage loss paid, and then you have the ability to pursue the wrongdoer for a liability claim. In a malpractice case, there is just one claim. It is the liability part of the auto claim, where what you're trying to do is recover for any damages you have, be it medical expenses, lost wages, pain and suffering. Those all are pursued toward the negligent healthcare provider.
Is it easy to bring a malpractice claim?
The statement I often use is there is no such thing as an easy malpractice claim.
And why is that?
Well, for a number of reasons. Number one, the lawyers that represent healthcare providers are very, very skilled people that, they do this, they do it very well. And the medical providers, as I would if I were a medical provider too, yourself, you can understand this, they want those claims defended vigorously. Whenever a claim is paid, one of the things that happens is that on behalf of a medical physician or medical provider is that they're reported to something called the National Practitioners Data Bank. Okay? That's a repository in California that individuals don't have a right to. There's been some attempts to allow individuals access to that, but that hasn't yet passed. But anytime that a claim is paid, it's reported there. So physicians naturally, that's one of the things that they try to hold back from doing that, okay, and they don't want to go there. What it does is if I want to get privileges with another medical institution or a healthcare or a health maintenance organization, that entity will give me a form to fill out in which I have to tell them if I've had any claims paid. If I have to list them there, and then they can go check to make sure that I've been honest against what's found at the National Practitioners Data Bank. So that's one of many reasons why medical providers vigorously defend these cases.
Is it true then that if it was settled out of court, that it doesn't have to be reported to that federal level?
No, that's not true. Even if claims are settled out of court, they still have to be reported to the National Practitioners Data Bank. Percentage-wise, I think it varies some as far as how many claims are truly settled out of court versus go through the litigation process in a medical malpractice setting. But even those that are settled before a lawsuit is ever filed, they still have to be reported to the data bank.
Okay. Can lay people or anyone access that bank to see if a doctor's name is there?
At this point in time, and I can't tell you everybody that can access, but you and I as lay people outside the scope of what we do otherwise could not access it. As a medical malpractice attorney, I wouldn't have access to it.
You wouldn't?
I would not.
Wow. Could you give us any examples of creative defenses then?
Well, even in the scenario we talked about before with your friend David, who marked up his body, and believe it or not, a lot of times in facilities nowadays, that's one of the things they do is they'll mark up, what part is supposed to be operated on. If for instance I went in and I kind of did what David did many years ago when I had a knee surgery done. I had knee surgery on my left knee, and I remember the only thing I kept saying before they operated on me was make sure you do the left knee. Let's say, for instance, they accidentally did the right knee, but when they went in and found out that I had a problem with the right knee too, not necessarily that would have necessitated surgery, but that I got a benefit from it, an argument that the insurance carrier or the medical provider may use is that because I obtained a benefit from it, either I don't have a claim and or what I have isn't worth much because I still gained a benefit from it. Some of the other things that come to mind in defending claims are, that whatever happened was a known complication of the procedure. Another that comes to mind that often has came up in the context of laparoscopic cholecystectomies or removal of the gallbladder laparoscopically, they'll say that the individual had an anatomical abnormality or an anatomical variant as such that there was no way I could have known that until I went in. And in the end, really what it comes down to is economics played a huge role in this, in medical malpractice claims too. They're expensive to bring, you need an expert and so forth. And that all those things play into what claims can be pursued really from a viability standpoint.
So are you saying then that there is a lack of medical experts who are willing to testify against doctors? Typically,
as a plaintiff, you almost always have to go outside the state you're in order to find a medical expert. Not always, but most of the time.
Are bad results always malpractice?
No, bad results are always not malpractice. In fact, the law even says straight up, there's case law that says that a bad result in and of itself isn't malpractice. A doctor or healthcare provider may do everything correctly and still get an undesired result, and in that scenario, it's not malpractice.
So other than wanting to keep your name out of the, what did you call it, National Data Bank?
Yeah, the National Practitioners Data Bank.
Is that a federal office? Or is that just some nonprofit organization in Washington, D.C. or someplace like that?
I think the repository is in California. I don't know if it's a national office or not. Individual, even on a state level, we have the Minnesota Board of Medical Practice. When I used to be an insurance adjuster and a claim was settled, I had to do two things at that point. I had to report it to the National Practitioners Data Bank, and I also had to send notice to the Minnesota Department of Health. So there are state agencies that investigate claims to determine if anything, if there should be a disciplinary action taken because of something happening. But the National Practitioners Data Bank is more on a federal level, and again, it's out of California, but I don't know any particulars beyond that.
So then, when you had to report that to the Minnesota Department of Health, who regulates the Minnesota Board of Medical Examiners, Minnesota Nursing, Minnesota Chiropractic, was that for personal injuries of all, including malpractice and auto collisions, both?
No, it's the only report claims to the Board of Health and to the National Practitioners Data Bank for any payments that are made on behalf of a healthcare provider. Not claims that are paid, if you settle an auto accident, that doesn't have to be reported. But if a medical provider commits malpractice and there's a payment made, that had to be reported to both institutions.
Good question here. How do you pursue a malpractice case? How does one pursue a malpractice case?
Well, it's not to say you couldn't do it on your own, but quite often, in order to do that, what you're going to need to do is find a qualified medical attorney, a malpractice attorney to help you do it.
Some attorney who is well experienced in that area and then therefore has a reputation of successfully pursuing those issues?
Correct. Somebody that has a reputation with the insurance companies, who they know and who can pursue them. What you need in order to bring any malpractice case in the state of Minnesota, you need to have a medical expert who will say that the care that was provided didn't meet the standard of care and that an injury occurred as a result of it. If you have that, you have what one needs in order to go forward with the case.
So then let's talk about money. How much does it cost to consult an attorney about a malpractice case?
Okay, just like with an auto claim, it doesn't cost the individual any money to go speak with an attorney. And again, these cases also are handled on a contingency basis. There are lawyers that will require a retainer up front if they have to consult an expert because it will cost money to do that. My office, I do not do that. I front all the costs. So if I have to hire an expert, I pay those costs first. If there's a recovery of money, they ultimately come out of the recovery. But it can be very expensive to pursue these cases. By the time you get to trial in many of these cases, you can easily spend upwards of $100,000.
What about empathy and sympathy? Is that important to you when these people come in and tell you of all of their problems?
Well, I think anybody that is hiring an attorney, there has to be some. They have to feel like the attorney can and does sympathize with the situation. I think that goes to the advocacy of the situation. It goes to me being able to present their cases to the best of my ability. If I can feel empathetic for them, if I can feel sympathy for them and understand what they're going for, even though the jury can't consider that in ultimately determining their verdict.
They can't.
Well, the judge will tell them they can't. The jury instructions will tell them that they are not to consider sympathy when deciding their verdict. Okay. It's got to be based on the facts. It can't be based on the fact that they feel sorry for them.
So they're saying it has to be based on objective evidence that the doctor did something wrong
Right.
or failed to do something correctly.
Right. They have to listen to the evidence, and after hearing it, not just because they feel sorry for the person, but because they think something was done wrong and that it generates to the level of malpractice, they can then compensate them. But as a practitioner, I think that empathy for my client and being able to really try to figure out how they're affected by an injury is vitally important to me being able to successfully pursue their case.
Now, in my 41 plus years of practice, thank God, I've never had a malpractice claim filed against me, and don't know of any that maybe should have, thank God again. What would be common malpractice issues with chiropractors, most common?
The ones that come to mind right away would be maybe this example. Someone comes in and has an extreme headache or some other cervical or neck issue that would prompt you to be concerned about whether or not you should treat them, and you go ahead and do it anyway, and they have a stroke or some other event afterward. That's the most prevalent that comes to mind.
What about in dentistry?
In dentistry, there's a whole gamut of things that come to mind, but the thing with dental malpractice cases, again, the economics are difficult to pursue. The ones there, I don't know if any one in particular comes to mind, but oftentimes, people, again, are concerned about their dental care, but there certainly can be issues, be it with, probably the most prevalent that I can think of is with implants, where they don't have enough bone there when they put the implant in, and or they allow a condition to go too long and it erodes the bone. But oftentimes there can be a whole gamut of things in the dental malpractice area.
So does the hospital or clinic bill the person even though somebody believes malpractice occurred?
Oftentimes they still will get a bill, and sometimes that's even what prompts the phone call to the attorney. They're upset because they think they got bad care, and then on top of it, adding insult to injury, they get a big bill, and they said, well, we don't think we should have to pay this.
And do you see it common that regulatory boards of healthcare providers take any action against doctors if the malpractice claim is pursued?
Well,
or is that a judgment call on their part again?
It is a judgment call, and part of the way the system's set up is it's somewhat, I don't know if I can call it secretive for lack of a better way to put it, but it is somewhat secretive as to what happens. Even when those things are reported, like to the Minnesota Board of Health, about the only way I would ever know that action was taken is if they had their license taken away or restricted for a period of time.
So do those regulatory boards wait for a solving of the matter before they would have any adjudication procedures of the doctor?
No, not necessarily. They could adjudicate earlier if they had the necessary evidence to do it, and they did it. The only way they would do that, however, is if they were informed about it ahead of time and were already investigating it, which does happen from time to time before the malpractice case resolved.
And then when the Minnesota Department of Health receives that issue, they do have a responsibility to send that to the respective regulatory board?
Yeah, from my understanding, this is from a few years back when I was sending things to the board, they'd always get a copy of the medical records, have someone review the records, determine if they felt it was necessary to investigate further themselves, and if they did, then they would go further. And if it ultimately rose to that level, they would, then proceed to take whatever action necessary.
Well, we've enjoyed having Mr. Benarat here again today. He's done 2 wonderful programs on personal injuries, and a third one, of course, malpractice is personal injuries. If you'd like a DVD or a CD on these programs, we're happy to provide those. Just contact us. The announcer will bring up our telephone number and address for you now.
House Call TV has been brought to you by the Fellowship of the Great Physician. For further information, please call at 651-484-8521 or visit our website at www.housecalltv.org. Until next time, thank you for listening to House Call.